our lives. But the tasks are great and challenging. We are yet to eradicate some of the pernicious problems of caste and other social divides. The claims to equality is complex, and accommodation to be made call for coordination between law, society, and the courts, without, however, creating new divides. The new entrance in the field of human rights, particularly social media, has thrown open challenges of regulation. As we look at the number of rural, unemployed, urban adolescents in crimes and jails, it is disconcerting. The day when jails are empty of youth, the day when jails become really soul transformative, the day when our courts at the initial levels become comfort clinics, the day when every citizen in need of justice and finds it at the doorsteps, that day ought to be the day the legal fraternity must be looking for. As we look at the disappointed rush for some employment, at the other of somewhat educated youth, it is disturbing. Economically deprived sections, minorities or otherwise, another set of our people whose justice needs also call for special investments. I do not wish to be talking stuff of distress. All this I say is that I share deeply the pains and agonies of all those who are in urgent need of constitutional justice. The new roads of constitutional justice for them have to be laid. The Honorable Prime Minister always listens, and his heart and mind never rest without listening. The 200 and odd years of constitution making across the globe and their duration tell us great lessons. The fragile democracies in various parts of the world teach us lessons. The loss of ability of people in certain countries to staunchly abide by democracy and stand firm by rule of law are also lessons. It is only by keeping agile on our freedoms and freedoms of those in lack of it. It is only by swearing by an open society where all distinctions can melt that we would be keeping faith with the Constitution. The legal profession and the courts are twin gateways. I do not propose to dwell on themes only of concern to the Supreme Court bar. We are only a microcosm. However, some issues of concern may be flagged. It is important that government stops overloading the court with endless statutory appeals, alongside a seamless and huge flow of cases from high courts. The conversion of Supreme Court into a small causes court must stop, even though for one in trouble, any court is good enough. Whether we keep engaging our thoughts on a National Court of Appeals or not, we need to strengthen our high courts and also decongest them, which alone can stem the flow of work in the Supreme Court. Our property dispute laws must undergo review and must become settlement commissions away from adversarial motions. Our family courts must become family comfort institutions. For doing all this, we need a permanent law reforms commission with legal reforms wing, court reforms wing, coordination wing with the courts, and a dedicated research wing connected to law schools. The vast spread of our people in varied deprivations who are justice hungry remain untouched. They lack public defenders' assistance. They lack neighborhood legal service provisions which must serve them 24 hours like hospitals. Every panchayat must have a legal service provision. In a digital age, making this happen cannot be a problem. The structure of free legal services, even in semi-urban and urban, are still far from matching the needs of demands. Most important and radically new ways of conceiving and organizing their basic needs through innovative institutional structures need to be explored. Socio-economic entitlements commissions, which can resolve social and economic needs and demands of deprived sections of the community, may be conceived to relieve courts from inadequately addressing them. Also, the need to come to courts to settle matters of salary or pay or pensions or retrial benefits must cease. If there be a justice provision tax on the rich and the able, let it be conceived. I suppose the administration of justice comprehends all means of fulfilling these tasks. For long, governments have been talking about litigation policies. There is no reason why this policy cannot emerge. Every department must have a resolution wing with a competent and independent legal equipment to resolve fact-based issues. And every matter need not be a legal dispute matter. Only complex legal issues which cannot be otherwise settled must go for institutional resolution. I am confident that the government will lend its ears to an earnest Attorney General to draw a quick roadmap and all the above. If only we dedicate 1 year exclusively for each subject, we can progress with great dispatch. I think rule of law is a non-violent revolution. We do not need any violent revolutions, as all such revolutions are paths of totalitarianism. The more and more of rule of law means room for no violence. Bharat can lead the way by setting its own benchmarks. I would like to look for the day when the West may come for learning from us on justice standards. Colonialism of minds and peoples will then cease. By doing all this, our constitution will be beyond reputation, and then refutation. Let us continue to march on the grand journey towards care of all and compassion without discrimination. I conclude my speech with a poetry address to my motherland. O nation of great mind and thoughts of past so long and cradles many, that nurtured knowledge of shades many, many. O nation of people with ancient roots, with entanglements thin and bosoms lodge. O nation that know the dark divisions of faith and caste, like spider webs can trip and trap. O nation of many tongues and cultures, faiths and creeds, and blends and bonds, of fibers strong, why bleed our minds, why freeze our hearts, why fence our homes, with petty thorns, swords once drawn are poison strong, words once dropped are slipping weeds. Fold all your clashes, fold all your noises. Little divides with constant chases can grow to seismic seasons quick. In composure, do all things flourish. In common pursuits of common weal, little skirmishes do dissolve. O nation of paths in beauty drawn, in common resolve of love for all, let our oars do swing and hail our life. Thank you for your attention.
Thank you, sir. May I now request the Honorable Union Minister of Law and Justice, Shri Kiren Rijiju, to address the audience.
Honorable Prime Minister, Shri Narendra Modi ji, Honorable Chief Justice of India, Justice D.Y. Chandrachud, Honorable Supreme Court Judge,
Justice Sanjay Kishan Kaul, Honorable Judge Supreme Court of India, Justice Abdul Nazir, Honorable Judges of the Supreme Court, Honorable former Chief Justice of India, my colleague S.P. Singh Baghel, the Honorable Chief Justices and the Judges of the High Courts, the Attorney General for India, Sri R. Venkat Ramani, Solicitor General Tushar Mehta, President Bar Council of Supreme Court Bar Association, Sri Vikas Singh, Chairman Bar Council of India, Sri Manan Kumar Mishra, senior officers of the Government of India, friends from media, ladies and gentlemen. It is my honor to address this very august gathering to celebrate the Constitution Day. Constitution Day, or commonly referred as Samvidhan Divas, is annually celebrated to mark the adoption of Indian Constitution by the Constituent Assembly in 1949, and also to remind us the significance of the historic day. Constitution is the bedrock upon which Indian nation stands and continues to achieve great heights every passing year. Today, this occasion gives me the opportunity to convey my gratitude towards the makers of the Constitution and also to promote and to reaffirm our constitutional values and reiterate the constitutional promise of justice, liberty, equality, and fraternity towards the citizens of this nation. It is also an occasion to remember with gratitude the struggles and the sacrifices of our founding fathers. The founding fathers placed immense responsibility on the coming generations of countrymen to take the country forward in the path of progress. It would be apt to recall the words of Baba Saheb, Dr. B.R. Ambedkar, when he cautioned us by saying, "Let us not forget that this independence has thrown on us great responsibilities. By independence, we have lost the excuse of blaming the British for anything going wrong. If hereafter things go wrong, we will have nobody to blame except ourselves." Justice is the foremost introductory vision and aspiration that the people of India have promised to give to themselves and its generations. The constitutional promise of equal justice is based on equal opportunity, and it is also a dream emanating from Article 39A. It is our constant endeavor to bring down barriers for accessing justice through integrating technology and other meaningful tools on making information accessible on a routine basis and in an easy to understand manner. In a country as large as ours, last mile delivery of justice remains critically challenged. New solutions have to be generated, integrated, and interoperated across various available legal platforms to actualize the last mile delivery of legal services. From courts to citizens, quick, simplified, and affordable access to justice should be the buzzword. To accelerate the movement of access to justice in India, the power of indigenous technology is being harnessed to mainstream legal aid and legal empowerment in the society. Now, seeking pre-litigation advice and consultation is a matter of doorstep delivery. It has been made possible through telelaw services wherein a citizen can connect via teleconferencing facilities with a dedicated pool of panel lawyers through downloading the telelaw mobile app or reaching to their near common service center within their villages. 25 lakh people have benefited from this service. In next 5 years, 1 crore plus citizens would be rendered with advice and consultation. To amplify the outreach of access to justice, legal literacy and legal awareness is being prioritized and made accessible in regional, local dialects using innovative techniques, both physical and virtual, of dissemination. To consolidate all these initiatives, Department of Justice has formulated a pan-India scheme on access to justice titled Designing Innovative Solutions for Holistic Access to Justice. In a vast country like India, where 65% of total population still lives in rural areas and where regional and local language is the medium of understanding, in most of the states, language becomes one of the perceived barriers in ensuring universal access to justice to the citizens of the country when legal material and legal terminology are not available in local language understandable by the common man. As it is, the Indian Constitution recognized 22 major languages of India in the 8th schedule of the Constitution. Honorable Prime Minister Modi ji on multiple occasions has highlighted the need to encourage local language in courts to increase the confidence of the common man of our country in judicial system and to make them feel connected to. In this context, I am happy to inform that under the aegis of the Ministry of Law and Justice, the Bar Council of India has constituted Bharatiya Bhasha Samiti, chaired by former Chief Justice of India, Honorable Justice S.A. Bobde. The committee, as a first step, is listing out words and phrases which are most frequently used in various branches of law, such as civil, criminal, and constitution, for developing a common core vocabulary close to all Indian languages for the purpose of translating legal material into regional languages. Such a common core vocabulary for all Indian languages will also help in translating legal material from one Indian language to another. By doing so, this will enable availability of law textbooks and judgments, orders in local languages to students pursuing legal education as well as administrators and litigants, etc. Further, this will also facilitate working of courts in local languages. Once the medium and mode of legal education starts using the regional languages, it would pave the way of creating a local language ecosystem under which the entire judicial system would operate. Towards this end, our legislative department of Ministry of Law and Justice has already prepared a glossary of 65,000 legal terms. We plan to digitize this glossary of 65,000 words and make them available to all public in searchable format for usage for all. Simultaneously, all efforts will be made to collect a Legal glossary is already published in regional languages, and to digitize it and also to make it available to the public in a searchable format. Therefore, by selecting the best available translation tool and by using artificial intelligence technology, a mechanism for speedy, large-scale translation of legal terminology of Indian regional languages can be put in place to strengthen the ecosystem of local language. As part of Prime Minister's ambitious Digital India program, e-courts mission mode project will be a building block for paperless courts in future. This will ensure a transparent and speedy justice delivery system, an easier file storage and retrieval system, instantaneous access to voluminous records, thus increasing efficiency, making justice more accessible. I would like to give my sincere thanks to Honorable Prime Minister for making available adequate funds for e-courts mission mode project for creating the IT infrastructure in the courts. This has enabled the judiciary to function even during COVID period, wherein more than 2 crore virtual hearings have been held by the courts across India, making India a world leader in virtual hearings. The phase 2 of the project is nearing its completion. In the end, I would like to mention that on this auspicious occasion, we worked as a team from the government side under the visionary leadership of Honorable Prime Minister. We are doing everything possible to strengthen the Indian judicial system and also to have a very close, cordial relationship with the Indian judiciary. And I am also fortunate that all the Chief Justices of India, the previous 2 former Chief Justice and the present Chief Justice, and the team of the Honorable Judges in the Supreme Court, as well as the High Courts led by the Honorable Chief Justices, we have shared very cordial relationship and identified those issues which we have to deal collectively. On this auspicious occasion of the Constitution Day, I once again thank all those participants who are here. With your guidance, your vision, and your active support, we will definitely make India the most vibrant democracy in the world. Thank you very much. Jai Hind.
Thank you, sir. May I now request the Honorable Chief Justice of India, Dr. Justice Dhananjay Yashwant Chandrachud, to address the audience.
Namaskar. The Honorable Prime Minister of India, Shri Narendra Modi ji, the Union Minister for Law and Justice, Shri Kiren Rijiju, Minister of State, Shri S.P. Singh Baghel, my distinguished colleagues, Shri Justice Sanjay Kishan Kaul and Shri Justice Abdul Nazir, my brothers and sisters on the bench of the Supreme Court, Chief Justices of the High Courts, Judges of the High Courts, the Attorney General for India, Shri R. Venkatramani, Shri Tushar Mehta, Learned Solicitor General, the President of the Supreme Court Bar Association, Shri Vikas Singh, Shri Manan Kumar Mishra, Chairman Bar Council of India, our most valued guests who are in physical attendance, and citizens of India who have joined us virtually. I have pleasure in welcoming in our midst the Honorable Prime Minister of India. We are gathered here to celebrate the adoption of the Constitution of India, the foundational document of the world's largest democracy. Lawyers and judges spend their time and years unraveling the text of the Constitution. But the story of the Indian Constitution is not a story only of legal text and legal interpretation. It is a story of human struggles and sacrifices. It is a story of undoing injustice against the marginalized sections of our society, the women, the disabled, the Dalits, and members belonging to tribes and segments situated in far-flung areas of the country. It must be remembered that the marginalized communities were the first to plant the seeds of the constitutional ideas of liberty, equality, and fraternity on Indian soil. The first wave of resistance against the colonial power came from the indigenous communities of India. Our constitution is a social contract entered into between those who were in power historically and those who were oppressed and sought to change the power hegemony and chose to govern themselves. Coincidentally, this year marks 75 years since our nation attained independence. India's liberation from colonial rule and the drafting of the Constitution were simultaneous projects. The prolonged struggle for independence culminated with the demise of the colonial reign and the birth of an independent nation governed by self-rule. However, the death of the colonial regime was not accompanied by a simultaneous birth of constitutional values that we hold on so dearly to. When India gained her independence, she was invested with social evils. As the first Prime Minister said on the eve of independence, the past clings on to us still in some measure, and we have to do much before we redeem the pledges we have so often taken. That has been the continuing constitutional project. As the Supreme Court said in its judgment in 2018 in Indian Young Lawyers Association, besides the struggle for independence from British rule, there was another struggle going on since centuries and which still continues. That struggle has been for social emancipation. The Constitution of India is the end product of both these struggles. The Constitution of India is to a large extent aspirational, for it seeks to deliver political freedoms and civil rights, attempting to shrug off the colonial baggage. It seeks to remedy the injustices that are suffered in a socially hierarchical society. When the Constitution was adopted, the social, political, and economic realities of our nation were in stark contrast to the aspirational ideals in the text of the Constitution. The Constitution entrusted the legislature, the executive, and the judiciary with the role of bridging this gap between constitutional ideals and social reality. I'm conscious that colonial and pre-colonial courts followed an approach of reluctance, disinclination, and inaction in protecting the rights of citizens. For instance, scholars and historians have documented the refusal of colonial courts to interfere in cases involving socio-religious custom, even if the rights of the marginalized were violated. With the birth of constitutional democracy, the culture of reluctance was replaced by a call for a dedicated judiciary to protect the rights of citizens. All judges across the courts in India, ranging from the district courts to the Supreme Court, must reflect upon the constitutional vision of securing justice, equality, and liberty. There is a need for us to introspect on our actions and decisions and to question our own prejudices and preconceptions. For until we open our minds to multiple views of persons with varied lived experiences, we would be lacking in our role as judges. An institution thrives with time only when it functions democratically. I believe that as the Chief Justice of India, it is my responsibility to collaborate and consult my sister and brother judges at the Supreme Court, the Chief Justice and the judges of the High Courts, members of the district judiciary, and the stakeholders of the institution. It is crucial that we tap on the experience of the diverse section of people who are part of the judiciary. Their knowledge and understanding would undeniably strengthen the institution. That is why it is all the more important that the representation of marginalized communities and women in the legal profession and the judiciary is enhanced. The Indian courts have been at the forefront, protecting the rights of the marginalized groups and upholding the rule of law. The jurisprudence that has emanated from our courts in India
has influenced decisions in far-flung nations, as diverse as Australia, Kenya, South Africa, Jamaica, Uganda, Fiji, Sri Lanka, Bangladesh, Nepal, Malaysia, and Singapore, which share similar problems. In a nation as large, diverse, and graded as ours, the paramount challenge that the judiciary as an institution faces is to ensure that the justice delivery system is accessible to everyone. Challenges require dedicated actions. The Indian judiciary has been adopting several measures of institutional reforms with a single objective, and I borrow the celebrated phrase of American civil rights activist Dr. Martin Luther King Jr. to describe it: to bend the arc of the moral universe towards justice. We have been adopting technology to improve the working of courts. It is of supreme importance and necessity that the courts are remodeled to reach out to the people instead of the people reaching out to the courts in their quest for justice. To ensure that the courts reach out to the people, it is essential that the process of litigation is simplified and made citizen-centric. Though the judiciary's engagement with technology gained prevalence during the COVID-19 pandemic, we must not dismantle the infrastructure but build upon it. And I would earnestly request the Chief Justices of the High Courts to ensure that the technological infrastructure on which public funds have been spent is not dismantled but strengthened further. The Supreme Court now functions in a hybrid mode with both online and offline courts, which enable lawyers and parties in person to appear from different parts of the country. Though the Supreme Court is located on Tilak Marg, the Supreme Court is a Supreme Court for the entire nation. As the Chief Justice, I'm attempting to adopt technology-based services in the listing of cases and court hearings so that institutional flaws such as delays in listing and hearing can be removed from our vocabularies. The E-Committee of the Supreme Court of India uses technology to make the justice delivery system more accessible and citizen-centric. The National Judicial Data Grid is a repository of 77 lakh judgments of the High Courts that are available to every citizen free of cost. Additionally, various citizen-centric services are employed to reach out to the people at the grassroots level. While technology has ably aided us in ensuring functionality of the judiciary during the pandemic, technology must be augmented with institutional reforms to resolve the chief issues of access to justice. The first interface of the people with the judicial system is the district judiciary. It is thus of paramount importance that the district judiciary is strengthened and supported. The district judiciary must be lifted from the mindset of being a subordinated judiciary. Today, the Honorable Prime Minister of India is present here to launch the e-initiatives, namely the virtual justice clocks, the Justice IS mobile application 2.0, digital courts, and S3 VAS websites of district courts. The virtual justice clock is a platform where information available through the National Judicial Data Grid is made available to the public. Virtual justice clocks for the District Judiciary of India are a real-time informative public dashboard which provide information in 3 levels, covering all the states, districts, and court establishments in India. The dashboard provides real-time status which is refreshed and updated every 15 minutes. The Justice Mobile App 2.0 is developed for the judges of the district courts in the country. The app is provided to judicial officers to monitor pendency and disposal of his or her court at the handset 24/7. Digital Courts is a green initiative of the Indian judiciary in the form of a desktop app that has been developed to make courts paperless or digital. It provides an easy-to-view case files documents while sitting at home. Judges can view all the case-related pleadings, charge sheets, court orders of both civil and criminal cases which aim at making the court paperless. And finally, the initiative's S3 VAS website. The acronym S3 VAS stands for Secure, Scalable, and Sugamya Website as a Service. Through the Digital Court and S3 VAS initiatives, the websites of district courts are being upgraded from the existing system
to a platform which is secure, scalable, and accessible. Content published on the website is accessible so that even persons with disabilities, including visual disabilities, would be able to access the information using assistive technologies. These initiatives reflect upon the commitment of the Indian judiciary towards providing access to justice to our own citizens. Our endeavors to enhance access to justice, this must not be understood in narrow terms of enriching the experience of those who are already in possession of access, but by reaching out to those groups and communities that are denied basic rights. Access to justice must be defined in the expression of upholding the faith and perception that the general public holds in the legal system. I can assure everyone that the initiatives launched today are a part of a larger technological and institutional advancement of the Indian judiciary to ensure that even the most disadvantaged communities in the country do not stumble while reaching out to justice. Before I conclude, I would like to emphasize on the relevance and constitutional values, not just to the judicial branch, but to all institutions and sections of the society. The evolution of a society can only ensue on the foundations of liberty, equality, and fraternity, the trinity of values highlighted by Dr. Babasaheb Ambedkar in his last address to the Constituent Assembly. Therefore, I appeal to the young minds to reflect on the social realities of India and work towards achieving fraternity by dedicating themselves to the cause of justice in whatever way possible. Sometimes, change happens by small acts of kindness. The heart and the soul of law, as it is administered in our courts, is our sense of compassion to our citizens. With that, I thank you. Jai Hind.
Thank you, sir. May I now request the Honorable Prime Minister of India, Shri Narendra Modi ji, to launch the e-initiatives of the Supreme Court of India as described by the Honorable Chief Justice of India.
E-Court is a mission mode project of the Government of India and implemented by E-Committee, Supreme Court of India. The following new initiatives under E-Court's project have been conceived. Virtual Justice Clock, Justice Mobile App 2.0, Digital Court, S3 VAS websites. Virtual Justice Clock. It is a real-time public dashboard which provides information of institution, disposal, case clearance rate, age-wise pendency, and listed cases at 3 levels, that is, national, state, and district. Now, citizens can access information from anywhere on the websites of the district court without physically visiting court premises. It is a step forward to fulfill the aim of transparency and accountability in judicial domain. Justice Mobile App 2.0. The app is provided to judicial officers to monitor pendency and disposal at fingertips. It is a tool available to judicial officers for effective court and case management. Now, the access to this app has been extended to the Honorable Judges of the Supreme Court, High Courts, and Principal District Judge of District Judiciary. It generates alerts and provides statistical information of pendency and disposal. Justice Mobile App will facilitate policy making for speedy dispensation of justice and easy access to justice. Digital Court. A green initiative where court records will be available to the judge in digitized form. Being integrated with e-filing and ICJS, the case papers e-filed by the litigants, so also the charge sheets, FIR sent by police machinery on ICJS platform will be available to the court 24/7. Digital Court provides multiple annotation options for judges to digitally read and add comments on case files through various digital tools. Customized reports can be generated through combination of various search criteria. Unique feature of working in offline mode is also made available. Digital court environment is cost-effective, safe and secure mechanism which will enhance the efficiency and ease of doing business in judicial domain. S3 VAS. Secure, scalable and Sugamya website as service, S3 VAS is a framework that empowers the district administration to generate, configure, deploy and manage websites for publishing specific information and services related to district judiciary. The websites comply with the mandatory guidelines of digital accessibility. 15 district court websites are ready to migrate to S3 VAS framework, and all district court websites will soon be migrated on S3 VAS platform. Let's join hands to build a futuristic judiciary to serve all.
On this special occasion, may I request the Honorable Chief Justice of India to present a memento to you, the Honorable Prime Minister of India. May I now request the Honorable Prime Minister of India, Shri Narendra Modi ji, to deliver the inaugural address.
भारत के मुख्य न्यायाधीश जस्टिस श्री डी.वाई. चंद्रचूड़ जी, केंद्रीय कानून मंत्री श्री किरण जी, जस्टिस श्री संजय किशन कौल जी, जस्टिस श्री एस. अब्दुल नजीर जी, कानून राज्य मंत्री श्री एस.पी. सिंह बघेल जी, अटॉर्नी जनरल आर. वेंकटरमणी जी, सुप्रीम कोर्ट बार एसोसिएशन के प्रेसिडेंट श्री विकास सिंह जी, सभी उपस्थित न्यायाधीशगण, सम्मानित अतिथिगण, देवी और सज्जनों, नमस्कार। आप सभी को और सभी देशवासियों को संविधान दिवस की हार्दिक शुभकामनाएं। 1949 में ये आज का ही दिन था जब स्वतंत्र भारत ने अपने लिए एक नई भविष्य की नींव डाली थी। इस बार का संविधान दिवस इसलिए भी विशेष है क्योंकि भारत ने अपनी आजादी के 75 वर्ष पूरे किए हैं। हम सभी अमृत महोत्सव मना रहे हैं। मैं आधुनिक भारत का सपना देखने वाले बाबा साहब आम्बेडकर समेत संविधान सभा के सभी सदस्यों को, सभी संविधान निर्माताओं को आदरपूर्वक नमन करता हूं। बीते 7 दशकों में संविधान की विकास और विस्तार यात्रा में लेजिस्लेचर, जुडिशरी और एग्जीक्यूटिव के अनगिनत लोगों का भी योगदान रहा है। मैं इस अवसर पर देश की ओर से उन सब के प्रति कृतज्ञता व्यक्त करता हूं। साथियों, आज 26/11 मुंबई आतंकी हमले का दिन भी है। 14 वर्ष पहले जब भारत अपने संविधान और अपने नागरिकों के अधिकारों का पर्व मना रहा था, उसी दिन मानवता के दुश्मनों ने भारत पर सबसे बड़ा आतंकवादी हमला किया था। मुंबई आतंकी हमले में जिनकी मृत्यु हुई, मैं उन्हें अपनी श्रद्धांजलि अर्पित करता हूं। साथियों, आज की वैश्विक परिस्थितियों में पूरे विश्व की नजर भारत पर है। भारत के तेज विकास, भारत की तेजी से बढ़ती हुई अर्थव्यवस्था और भारत की मजबूत होती अंतर्राष्ट्रीय छवि के बीच दुनिया हमें बहुत उम्मीदों से देख रही है। एक ऐसा देश जिसके बारे में आशंका जताई जाती थी कि वो अपनी आजादी बरकरार नहीं रख पाएगा, जिसके बारे में कहा जाता था वो बिखर जाएगा, आज पूरे सामर्थ्य से अपनी सभी विविधताओं पर गर्व करते हुए यह देश आगे बढ़ रहा है। और इन सब के पीछे हमारी सबसे बड़ी ताकत हमारा संविधान है। हमारे संविधान के प्रेम्बल की शुरुआत में जो वी द पीपल लिखा है, ये सिर्फ 3 शब्द नहीं है। वी द पीपल एक आह्वान है, एक प्रतिज्ञा है, एक विश्वास है। संविधान में लिखी ये भावना उस भारत की मूल भावना है जो दुनिया में लोकतंत्र की जननी रहा है, मदर ऑफ डेमोक्रेसी रहा है। यही भावना हमें वैशाली के गणराज्य में भी दिखती है, वेद की ऋचाओं में भी दिखती है। महाभारत में भी कहा गया है, लोकरंजनम एव अत्र राज्ञाः धर्मः सनातनः सत्यस्य रक्षणं चैव व्यवहारस्य चार्जवम्। अर्थात लोक को यानी नागरिकों को सुखी रखना, सच्चाई के साथ खड़े होना और सरल व्यवहार, यही राज्य का व्यवहार होना चाहिए। आधुनिक संदर्भ में भारत के संविधान ने देश की इन सभी सांस्कृतिक और नैतिक भावनाओं को समाहित किया हुआ है। मुझे संतोष है कि आज देश मदर ऑफ डेमोक्रेसी के रूप में अपने इन प्राचीन आदर्शों को और संविधान की भावना को लगातार मजबूत कर रहा है। प्रो पीपल पॉलिसीज की ताकत से आज देश और देश का गरीब, देश की माताएं बहनें,
उनका सशक्तिकरण हो रहा है। सामान्य मानवीय के लिए आज कानूनों को सरल बनाया जा रहा है। टाइमली जस्टिस के लिए हमारी जुडिशरी भी लगातार कई सार्थक कदम उठा रही है। आज भी सुप्रीम कोर्ट द्वारा शुरू किए गए ई इनिशिएटिव्स को लॉन्च करने का अवसर मुझे मिला है। मैं इस शुरुआत के लिए और ईज ऑफ जस्टिस के प्रयासों के लिए मैं आप सभी को बधाई देता हूं। इस बार 15 अगस्त को लाल किले से मैंने कर्तव्यों की बात पर बल दिया था। ये हमारे संविधान की ही भावना का प्रकटीकरण है। महात्मा गांधी कहते थे कि हमारे अधिकार हमारे वो कर्तव्य हैं जिन्हें हम सच्ची इंटीग्रिटी और डेडिकेशन के साथ पूरा करते हैं। आज अमृत काल में जब हम आजादी के 75 वर्ष पूर्ण करके अगले 25 वर्षों की यात्रा शुरू कर रहे हैं, तो संविधान का ये मंत्र देश के लिए एक संकल्प बन रहा है। आजादी का यह अमृत काल देश के लिए कर्तव्य काल है। चाहे व्यक्ति हो या संस्थाएं, हमारे दायित्व ही आज हमारी पहली प्राथमिकता है। अपने कर्तव्य पथ पर चलते हुए ही हम देश को विकास की नई ऊंचाई पर ले जा सकते हैं। आज भारत के सामने नित नए अवसर बन रहे हैं। भारत हर चुनौती को पार करते हुए आगे बढ़ रहा है। एक सप्ताह के बाद भारत को G20 की प्रेसिडेंसी भी मिलने वाली है। ये बहुत बड़ा अवसर है। हम सभी टीम इंडिया के रूप में विश्व में भारत की प्रतिष्ठा को बढ़ाएं, भारत का योगदान विश्व के सामने लेकर जाएं, ये भी हम सभी का सामूहिक दायित्व है। भारत की मदर ऑफ डेमोक्रेसी के तौर पर जो पहचान है, हमें उसे और सशक्त करना है। साथियों, हमारे संविधान की एक और विशेषता है जो आज के युवा भारत में और भी प्रासंगिक हो गई है। हमारे संविधान निर्माताओं ने हमें एक ऐसा संविधान दिया है जो ओपन है, फ्यूचरिस्टिक है और अपने आधुनिक विजन के लिए जाना जाता है। इसलिए स्वाभाविक तौर पर हमारे संविधान की स्पिरिट यूथ सेंट्रिक है। आज स्पोर्ट्स हो या स्टार्टअप्स, इंफॉर्मेशन टेक्नोलॉजी हो या डिजिटल पेमेंट्स, भारत के विकास के हर आयाम में युवा शक्ति अपना परचम लहरा रही है। हमारे संविधान और संस्थाओं के भविष्य की जिम्मेदारी भी हमारे इन युवाओं के कंधों पर ही है। इसलिए आज संविधान दिवस पर मैं सरकार की व्यवस्थाओं से, देश की न्यायपालिका से एक आग्रह भी करूंगा। आज के युवाओं में संविधान को लेकर समझ और बढ़े, इसके लिए ये जरूरी है कि वो संवैधानिक विषयों पर डिबेट्स और डिस्कशंस का हिस्सा बने। जब हमारा संविधान बना तब देश के सामने क्या परिस्थितियां थी, संविधान सभा की बहसों में उस समय क्या हुआ था, हमारे युवाओं को इन सब विषयों की जानकारी होनी चाहिए। इससे उनकी संविधान को लेकर दिलचस्पी और बढ़ेगी। इससे युवाओं में इक्वालिटी और एम्पावरमेंट जैसे विषयों को समझने का विजन पैदा होगा। उदाहरण के तौर पर हमारी संविधान सभा में 15 महिला सदस्य थी और उनमें एक दक्षयानी बेलियाउधन वो महिला थी जो एक प्रकार से
वंचित समाज से निकल करके वहां तक पहुंची थी। उन्होंने दलितों, मजदूरों से जुड़े कई विषयों पर महत्वपूर्ण इंटरवेंशंस किए। दुर्गाबाई देशमुख, हंसा मेहता, राजकुमारी अमृत कौर, ऐसे ही और कई महिला सदस्यों ने भी महिलाओं से जुड़े विषयों पर अहम योगदान दिया था। इनके योगदान की चर्चा कम ही हो पाती है। जब हमारे युवा इन्हें जानेंगे तो उन्हें अपने सवालों का जवाब भी मिलेगा। इससे संविधान के प्रति जो निष्ठा पैदा होगी वो हमारे लोकतंत्र को, हमारे संविधान को और देश के भविष्य को मजबूत करेगी। आजादी के अमृत काल में ये भी देश की एक अहम जरूरत है। मुझे आशा है संविधान दिवस इस दिशा में हमारे संकल्पों को और अधिक ऊर्जा देगा। इसी विश्वास के साथ आप सभी का बहुत बहुत धन्यवाद।
धन्यवाद माननीय प्रधानमंत्री जी। May I now request the Honorable Shri Justice S. Abdul Nazir, Judge, Supreme Court of India, to propose a vote of thanks.
Honorable Prime Minister of India, Shri Narendra Modi ji, and other dignitaries on the dais, ladies and gentlemen. It is indeed a matter of great honor and pride for me to propose the vote of thanks on the 73rd anniversary of the Constitution of India. The date today, that is 26th November, holds great significance for every year. It reverberates the beautiful and inspiring journey that we, the people of India, have traveled thus far since 1949, when the Constitution of India was adopted. Fast forward 73 years, today we stand as the largest sovereign, socialist, secular, democratic republic in the world, where the ideals of justice, liberty, equality, and fraternity are secured to all the citizens of India. This could not have been possible without the foundational guidance of Dr. B.R. Ambedkar and the monumental efforts of the members of the Constituent Assembly who drafted the Constitution in such manner and style that it not only recognizes the socio-economic and political rights and interests of 1.3 billion citizens, but also provides great adaptability to accommodate the changing needs of the times ahead without compromising on its basic structure. Swami Vivekananda once said, and I quote, "Every nation has a message to deliver, a mission to fulfill, a destiny to reach. The mission of India has been to guide humanity," unquote. In our mission of upholding the constitutional morality and values, we must arise, awake, but never stop. We, in the capacity as judges, strive to streamline our justice delivery system to make it more efficient and accessible for all, while ensuring that the judicial institutions are at the forefront when called upon to adopt changes with time and technology. I extend my hearty vote of thanks to Shri Narendra Modi ji, Honorable Prime Minister of India, Dr. D.Y. Chandrachud, Chief Justice of India, Shri Kiran Rijiju, Union Minister of Law and Justice, Shri Baghel ji, Minister of State, Shri R. Venkatramani, Attorney General for India, and Shri Vikas Singh, President, Supreme Court Bar Association, for gracing today's occasion by sharing their valuable thoughts. I thank each one of you for participating in today's function. Thank you all. Jai Hind.
तो आप देख रहे थे सीधा प्रसारण सुप्रीम कोर्ट से, जहां संविधान दिवस का मुख्य कार्यक्रम था और प्रधानमंत्री नरेंद्र मोदी ने सर्वोच्च
की 400वीं जयंती के सिलसिले में 3 दिवसीय कार्यक्रम के समापन सत्र को प्रधानमंत्री संबोधित करेंगे और उससे पहले वहां पर जो प्रदर्शनी है, जो वहां पर विभिन्न जागरूकता कार्यक्रम हैं, उनका जायजा लेते हुए प्रधानमंत्री दरअसल असम सरकार ने लचित बरफुकन की वीरता और देशभक्ति के बारे में अधिक जानकारी के लिए दिल्ली में 3 दिवसीय कार्यक्रम आयोजित किए और इस अवसर पर